Thank you, Mr. Chairman. Welcome to each of the nominees. Congratulations on your nominations. Mr. Fleming, let's start with you. You've had a number of questions today. I want to revisit the case of United States versus Brown. In that case, you represented a defendant who was charged with child pornography involving his two minor granddaughters. You argued that Congress did not mean to regulate child pornography when it outlawed producing visual depictions of minors engaging in sexually explicit conduct. The Supreme Court did not accept your argument. Explain that argument to this committee.
Thank you, Senator. And in doing so, I hope you'll allow me to clarify what I said earlier. There were two different aspects to Mr. Brown's case. One was there was child pornography or alleged child pornography that had been uploaded to the internet. And then there was alleged child pornography that he had produced, as you indicated, of his step-granddaughters. The child pornography alleged with regard to his step-granddaughters simply related to pictures that he took of his step-granddaughters, and the reason the government was prosecuting him for that was because he had taken them with items that had traveled in interstate commerce, like a camera, that was made by Toshiba or someone like that. And so what I was arguing as to the pornography alleged regarding his step-granddaughters, that because he simply took pictures and did not distribute that, it was simply intrastate conduct. We thought that created a constitutional question under the Commerce Clause as to whether it reached that intrastate conduct. We did not allege.
You also, after the Supreme Court didn't accept your petition, you then subsequently argued that the client did not produce, quote, lascivious visual depictions, even though the videos had pornographic content of the two granddaughters. Can you explain that?
Yes, thank you, Senator. Under precedent, when we talk about lascivious display of the genitals, precedent has indicated that's when the focus of the picture is on the genitalia, as opposed to just a general garden variety picture of a child who may not have clothes on. People often take pictures of children who are less than well dressed. The question was whether or not this was a lascivious display of the genitals, and we simply raised a factual question at the district court level for the court to decide whether or not this was in fact, as opposed to just a picture of children who may not be dressed.
So I'm thankful I don't know the specifics of the facts of this case, but I suppose I'm obliged to ask, how graphic are we talking about? There's one thing if someone has pictures of some kids playing in a bathtub. There's something else entirely if they're engaged in or simulating sexual conduct.
Thank you, Senator. These pictures did not in any way engage in sexual conduct. As a matter of fact, funny you should mention, one of the pictures was them taking a picture of a kid playing in a bathtub. And so that is one of the reasons why we asked the judge to make a call at the trial level and sentencing level as to whether or not these are in fact lascivious. And we thought there was
a judge conclude?
The judge concluded that they were, but we thought because of the nature of the pictures and bathtub picture, like you indicated, that there was an open question as to whether or not they should be considered lascivious, and we wanted the Court of Appeals to weigh in.
Let me shift to Ms. Brennan.
Okay.
Ms. Brennan, you defended a law professor, Aisha Bell Hardaway, who was supposed to objectively evaluate whether the Cleveland Police Department complied with a consent decree concerning excessive force. While Professor Hardaway was on the monitoring team, she made statements disparaging police officers and suggesting that they were, quote, trigger happy. They were, quote, brutal in interactions with black people. She also said that it was, quote, disingenuously obtuse for people to, quote, profess that all police officers aren't that bad. Do you share the views of Professor Hardaway?
Thank you for the question, Senator. I do not take a position on another person's views. In that context, I think much more was being said Ms. Hardaway was a representative of the court.
I'm sorry, I don't take a position on another person's views. Do you agree with what she said there? I'm asking what your views are.
I don't exactly remember the full statement that was made, so I can't put it all together. I know that that was part of a longer segment on a radio show. But Your Honor, much conversation was had with the court about statements made by Ms. Hardaway. Her full context as a member of the monitoring team was assessed, and the judge and the monitor in charge of that monitorship determined that Ms. Hardaway should remain as a member of the team.
But she resigned after public outcry, and you expressed disappointment that she was no longer ostensibly, objectively evaluating the Cleveland Police Department. Is that right?
I guess I don't understand where that question's coming from, Senator. I don't remember what I said that was in defense of Ms. Hardaway.
You said that she was, quote, an integral part of the police reform process, and you expressed disappointment to lose someone of her caliber after she resigned following her condemnation of the police. Is that accurate?
I don't think that's a full quote. I don't remember saying anything about condemnation of
No,
police.
that's not in the quote.
Okay, thank you. Look, her viewpoints, her participation as a member of the monitoring team had been important, and the monitor believed they were important, and the judge believed they were important. And as a
Madam Chair, I would ask unanimous consent to enter into the record the formal statement from Acting U.S. Attorney Bridget Brennan, which reads, the importance of diversity in thought and experiences to the police reform process cannot be overstated. Professor Aisha Bell Hardaway was an integral part of this dialogue, bringing a unique combination of local knowledge and legal expertise. Her presence in the monitoring team facilitated the process and successes we have seen to date, and we were disappointed to learn of her resignation. Thank you.